benches can be expanded. I believe that is the positions that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Nasir Abdullahi, that the senior bench is supposed, the judge bench is supposed to do this or the other. We can't help that. This is not coming from the petition.
What we'll do in some way is that we'll mention this matter tomorrow.
I'll appreciate. What time, my lord?
At 9.
Most obliged.
You will serve.
Most of the people actually here, we have served them, but we shall serve the notice of hearing.
All right.
The notice of hearing for the mention tomorrow at 9. I thought, my lord, the time would have been easier, because by the time I go to my office, there will be nobody to do some of this. Or probably 11.
You know, by the time we spend here means that even if you come at 10, you'll find us here.
My lord, what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11. What's the
My lord, I am asking in this particular file that you record my presence together with the other lawyers I mentioned earlier as appearing for the deputy president and the second respondent.
This one?
Yes.
The verified?
Yes.
But you didn't stand up and submit it. I thought you were not here.
Patiently wait.
This matter of 570.
Yes. If you look at the parties, the deputy president is the second respondent.
So you agree with the directions which you have given?
I accept the directions. And I will be here tomorrow at 11. Inshallah.
This particular matter.
Let's the same matter.
Yes.
570.
Yes, my name is Manzo. I wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and the fourth interested party? And permit me to only indicate the implication of the orders of the empowerment that were issued by the judge who directed the Chief Justice does empower you. To the best of my thinking and knowledge is that the prayer was granted as it is for the empowerment of 5 judge bench.
Mr. Jerry. Zero, yes.
There were 0.
We speak from the record. You had me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only 3.
That's correct, but I will address it more on that issue.
My lords, my lady. So we mention it tomorrow. Mr. Jerry, you say you come for which parties?
Your Lordship, I am here for the second and the fourth interested party.
Thank you.
Perhaps if I may make a request. My lord, there is a file that is live before you. and that is petition number 565 of 2024. We have requested, my lord, that you give directions in respect of the applications in that matter, because this process of taking quorum might take some time. And there are 3 cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the 2 applications that the court has identified as urgent. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts, so that these are important, but the applications are urgent. And the court has identified that urgency, because this will go on for 2 or 3 hours without any directions having been given in 565.
Lord, could we be on board together? We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
Mr. Man, what do you want to do in the bedroom?
We will discuss the execution of our plan. Can we allow the parties to come on record?
Mr. Demodi, the reason why we are mentioning these matters is to find out if any of them would be ripe for consolidation with the matter which is here, so that we don't duplicate.
Thank you.
My lord, perhaps as you consider that, let me put it on record that if you are considering whether they are ripe for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as urgent. If they are to come on board, they come on board and proceed from where we are.
Let us be on board first. We'll respond to you appropriately. Allow us, even the LSK former president, to be on record.
My lady and my lords, I just have a passionate plea to make. There are not many pleas. The first plea is we consider utilizing the ceremonial court on the ground floor because it is spacious. It's sufficient for all of us. That's number 1. Number 2, my request is this. The court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before? So that when we appear here, whatever time we indicate, we'll just fill our respective names and the court will be able to deal with the matter without the need of this back and forth. Number 3, my lords and my lady, I think the court needs to just be a little bit proactive. When you retreat, you may make 2 decisions. 1, either to determine the interlocutory applications, in which case you can frame issues for the parties to submit them. Or 2, if you're minded to hear the petitions themselves, then still frame the issues and forward it to us so that we're able to make progress. That way we make good use of the initial time that is very limited in this particular. I beseech you.
Thank you, Mr. Habi. Well taken.
As former chairman of the Council Science, let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, because we are too crowded, and the people want to listen, and the media and the members of the public, if it is possible, let us use the ceremonial hall.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
I wish to say that perhaps when giving directions, then and if parties, files are going to be consolidated, then it will be proper each person is served with the application so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
thank you.
My Lord, I was going to beseech the court, if we are to make progress, I'll beseech the court to invoke its powers under section 55, article 159, we will go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this where you're 20 lawyers, 50 lawyers on the other side, we will be coming to you. We'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions. And meanwhile, we'll be lamenting as we are now lamenting to you. So there are applications, both from this side and this side, certified agent. Meanwhile, we are spending a lot of time, each of us from whatever side, starting to raise this or other housekeeping issue. I beseech you, my Lord, in a matter like this, the court must be very firm. It must run the counsel. The court itself must have very clear direction. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times.
We have agreed on that, and what we ask is let us mention these matters so that we know how they relate to the other matters which are before the court. So we have mentioned 570. We have mentioned, we have 570. We have mentioned 570. There's
570.
This 550. 550.
570.
We have mentioned E570. E550. Speaker of the National Assembly versus the Gachagua.
My Lord, this file is already consolidated under the cohort of 552.
$550.
No, I'm sorry, my Lord, that was not.
Yes. 550. Who's in 550? Who is in 550?
My Lord, mine is 572.
I'm asking 550.
Yes, my Lord, 550. My Lord, we appear for the first respondent.
I guess you can tell us who is the
petition. The petitioner, my Lord, is the former deputy president, my Lord, represented by my Lord Senior.
My Lord, I appear for the deputy president, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed weighty issues, which is why we are here. Let's not join the rush.
For the first petition.
For the first petition. I thank you.
My Lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Muruga.
That matter, my name is Mukele. I appear together with Ms. Angie and my senior professor, Brenda, for the third and fourth respondent.
Yes. Who else is in this matter? So, for the petitioner, Mr. What are the issues in this matter? Are they relevant to the consolidated petitions?
There are so many files here.
This is
the same team of lawyers.
Yes.
including myself, that I gave when we came for the ruling, is appearing for the deputy president.
So what I'm asking, is it going to be consolidated or is it standalone?
One of the ones that we are consolidated.
My lord, sorry if I appear repetitive.
Yes, speak, please.
For you to be able to progress, I beseech you adjourn this matter tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective of what we propose. Otherwise, you will not make.
We are alive of that fact, Mr. Harvey, but you know,
It's my advice.
it is the councils who will be saying that they are right to be heard, even on petition, even if the slightest issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from you side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed the petitions? You can make a submission which this court can consider.
My Lord, if I may, just to guide the court, and on this account, I will bring it as senior counsel. My Lord, there are urgent applications before you. The applicants or the petitioners had their bite yesterday on a preliminary objection that the court has ruled on this afternoon. My Lord, we have an urgent application that was filed before you, dated 18th October 2024, for discharge of the conservatory orders. Whatever decision this court makes can be either way. We lead to directions on the hearing of all the consolidated petitions. Some of the petitions, my Lord, deal with issues or causes of action that arose before, my Lord, the impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservatory orders. I think, my lord, that's the only way we can move, because they have had their bite, let us have our bite as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Jenda. What I'm saying is that let's mention these files. We are on the third one, and if you have not been interrupting, perhaps we'll be through with them. 550, I've recorded the forum, and what I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone?
Can we deal with that? We're not more. We only do it. Because I need to.
Because there is a
We only deal with the court. Consolidation has implications. I need to consult my team.